What do I need to prove to get an order of protection in Illinois? Navigating the legal process for obtaining an order of protection in Illinois can be daunting. Understanding the requirements and procedures is crucial for anyone seeking this form of legal relief. This guide outlines what needs to be proven to secure an order of protection in Illinois. Legal requirements for obtaining an order of protection. Illinois courts aim to prevent potential harm through orders of protection. These orders serve as injunctive measures, instructing a person to refrain from specific actions that could lead to abuse. According to the Illinois Domestic Violence Act of 1986, courts must be presented with sufficient evidence to grant such orders, which are meant to protect victims of domestic violence and prevent further abuse. Abuse criteria. To issue an order of protection, the court must find that the petitioner has been abused by a family or household member. Abuse in this context can take several forms, including physical abuse, harassment, intimidation of a dependent, interference with personal liberty, willful deprivation. Evidence needed for an order of protection. For the court to issue an order of protection, there must be a finding of abuse. Abuse is broadly defined to include physical abuse, harassment, intimidation, interference with personal liberty, and willful deprivation. Harassment involves knowing conduct that causes emotional distress without a reasonable purpose. Specific actions that qualify as harassment include disturbing someone at their workplace or school, repeatedly calling someone at home or work, following someone in public, keeping someone under surveillance, threatening or concealing a minor child, intimidation of a dependent. This occurs when a dependent person is subjected to or witnesses physical abuse or confinement. This applies to individuals who are dependent due to age, health, or disability. Interference with personal liberty. This involves compelling someone to do something they have the right not to do, or preventing them from doing something they have the right to do, through physical abuse, harassment, intimidation, or willful deprivation. Willful deprivation. This means intentionally denying someone essential needs such as medication, medical care, food, or shelter, thereby exposing them to risk of harm. The process of securing an order of protection. Emergency petition. For order of protection, most petitions start as an emergency petition. The petitioner needs immediate protection, and the court can issue an emergency order based on the petitioner's testimony and evidence. This order typically lasts for 14 to 21 days but can be extended until a full hearing is held. Standard of proof. The petitioner must prove their case by a preponderance of the evidence, meaning it must be more likely than not that the abuse occurred. In emergency hearings, this standard is often easier to meet because the respondent is not present to counter the claims. Full hearing. For a plenary order of protection. A plenary order requires a full hearing where both parties present evidence. The court does not consider evidence from the emergency hearing. The petitioner must provide corroborating evidence to support their claims, such as phone logs, photos of injuries, or witness testimony. Corroborating evidence. Corroborating evidence strengthens the petitioner's case. Examples include phone logs showing harassing calls, photos documenting injuries, text messages or other communications demonstrating harassment. Additional relief and findings. An order of protection can include various forms of relief, such as prohibiting the respondent from possessing firearms if they pose a credible threat. The court must consider the nature, frequency, and severity of past abuse and the likelihood of future harm. The court also assesses whether the relief sought would cause undue hardship to the respondent. For more detailed guidance and support through the process, contact our experienced attorneys. If you need assistance with obtaining an order of protection or have any other family law concerns, reach out to our law firm. We provide free consultations to help you understand your rights and options. Call us at 773-334-6311 or visit our office at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, United States. Our dedicated team is here to support you through every step of the legal process.